This conference will now be recorded.
Welcome to Serving Notices webinar. My name is Darryl Kwong. I'll be your presenter for the next 5 to 10 minutes. I just wanted to cover this subject purely from the fact that this does cause a few problems in relation to getting possession of a property. So I wanted to really just go through the different options that a landlord and agent has when they're serving relevant notices and making sure it's done obviously correctly. So the first slide I want to bring up, and you can see hopefully my spotlight that comes up there. I just wanted to talk very quickly about the different types of notices that you may serve. Now, the one that I want to concentrate on today is regarding the possession notices, because that's the one, as you can see with my spotlight, which causes the biggest problems in terms of the court. So when we talk about the different methods and the service time that you allow for serving notices, I am really referring to Section 8 and Section 21 notices where you're seeking possession because the tenant's in rent arrears, or under Section 21 where you're looking to get possession back at no fault, or there's no tenant fault, shall I say. There are other legal notices that you have to serve, and potentially, again, as we go through it, you'll see the importance of making sure that you do have evidence of serving notices, but you won't have to follow the rules in terms of service time. So a Section 3 notice is a change of landlord. So if you're changing a landlord, then you've got, or the landlord has changed, or the owner has changed, then you may need to serve a Section 3 upon the tenant to say, by the way, there's a change of landlord, and this is where you serve your notice. The same with Section 47 and 48, really. That's an address for service of notice, or making the tenant aware where they do serve notice if they wanted to leave, for example. So those 3 notices are important in relation to making sure that the conduct of the tenancy is done correctly. So making sure that you have served them those notices is quite important. Section 47 and Section 48 you will find within the tenancy. So in a sense, you don't have to serve it to them because it will be within the tenancy itself. A Section 3 notice is a notice that you may need to serve, as I said, when there's a change of owner / landlord. So again, evidence that you've done that, so the tenant can't then accuse you of not serving that notice. So again, the evidence is the important part of that. And then the last one on that particular slide is the inspections and gas safety. So if you wanted to do a routine property inspection, which your tenancy allows, or you wanted to do the really important gas safety checks, again, how much notice do you need to give to the tenant? So when we talk about notices, we're just really talking about informing a tenant about potentially when you're going round. But again, it's really important that you have evidence of having served those notices of your intention to enter the property, so they can't accuse you of breaching their right to quiet of enjoyment, harassment, or whatever it's going to be. So the last point on that slide, or the last 2 issues on that slide, are really important in relation to protecting yourself from accusations potentially of entering the property without their permission. And one time where a client was accused of stealing quite an expensive ring, but the judge actually in the court case said because the agent had, or the landlord had, proof of serving notice of their intention to enter, that he felt that the tenant would not have left a very expensive ring on the sideboard. So that evidence and proof that he had served his intention of entering the property actually saved that particular client from having to pay quite a large sum of compensation to a tenant. So from that perspective, it's important as well. But on this particular webinar, we're just going to really concentrate on Section 8 and Section 21s, because that's the one that potentially causes the most problems, because a judge or the defence team on behalf of the tenant could argue that the notice is invalid because it hasn't been served A, correctly, or B, the amount of time given to the tenant in relation to service time, again, was not sufficient. So we'll go through those different methods and what service time that you'll need to give to tenant over the next couple of slides. So the next slide talks about evidence. And again, for those that have been on my courses before, it's so important because in the end, the onus, as you can see here, is upon the landlord or the agent, depending on who's serving it on their behalf. So from that perspective, for those that have not been to court before, it's broken down into, or the courts are broken down into 2 channels, if that's the right way of saying it. The first one is what we refer to as civil, which is what we're dealing with really, sort of landlord and tenant law, that type of stuff. So the other one obviously is criminal. So we're not obviously involved with that, thankfully. So we're just going to stick to the civil route. That's where most, obviously that's where claims for possession, claims for money are made. So the onus very clearly is on the landlord or agent to prove that they've done X, Y, and Z. So my 3 words at the top is something I always say. It's my mantra: evidence, evidence, evidence. What evidence do you have that you serve that notice upon the tenant or whoever you need to serve it upon? So that's so vitally important. You can't just go on verbal, I served it, because the judge may not believe you, sadly. He may say, or she may say, what evidence do you have that you served it? And you may have served it 6 months ago. So from that perspective, you may have forgotten what you did. So the importance of writing down and having evidence of what you have done can't be understated. And that's the importance of this webinar, really making sure that you have all your ducks in a row. So when you do go to court, the likelihood of a judge or a defense team arguing or alleging your possession claim is invalid is hugely reduced. So evidence, evidence, evidence. The balance of probability, who does the judge believe? That's why ultimately the onus is put upon you as the landlord stroke agent. Now, the important thing to remember, that's the next point down, or the next section down, is that you only need to prove that you have validly served it. Now, when I talk about that, and you'll see that obviously on the next point on that particular section, is that there may be many reasons as to why the tenant doesn't physically actually get the notice. So, for example, if you put it through the front door of one, the high street, they may not be in. They may be on a long holiday. They may be in prison. They may be in hospital, sadly, like my father was recently for a long period of time. So from that perspective, you've got to prove only that you validly served it, and your only obligation is to validly serve it to the property. It's not your responsibility to work out where that tenant potentially or the occupier has gone. So from that perspective, you've only got to prove that you validly served it, and we'll go through the methods on the next slide, and not that they received it. Obviously, if they can sign to say they've received it, then great. That removes all the ambiguity in the world. But there may be certain circumstances, what I've said, where they won't sign it. And obviously, if they know you're going to serve notice and they're not paying the rent for argument's sake, it's highly likely they're not going to sign anything that you send or acknowledge receipt of anything you send, because they know you're going to send it potentially and be awkward. So from that perspective, in most cases, it's proving that you validly serve the notice, which is the important part, not that the tenant has physically received that notice. And then again, follow potentially what your tenancy agreement says, because in the end, the bottom section of this particular slide talks about how can you serve notice, what are the options available to you, and we'll cover that in a bit more detail on the next slide. So the Law of Property Act 1925, it just talks about what you should do when you're serving notice, and one of the things it does talk about is post and also by hand delivery. So they're the 2 methods, which are the bomb-proof methods, which you'll see on the next slide, which you should always have. People say to me, can you serve it by email? You can certainly serve it by email, but I would not rely on email on its own, purely from the fact that in 1925, as per the legislation, emails didn't exist. And again, whatever's in your contract as well, what does your contract say, or your tenancy agreement say about serving notice upon the tenants? So you've got to read and understand what you're obligated to do from a legal perspective, but also from a contractual perspective as well. So that particular slide here is all about evidence. What evidence do I have that I've done X in case that the other party accuse me or allege that they didn't get the notice? And again, as I said very clearly on this particular slide, if they haven't received the notice, that's fine in law, so long as you, as the landlord or agent, can prove that you have validly served it. And again, that's why it's important to read your contract to make sure that your contract very clearly stipulates how notice is served. So mine will say first class postal with proof of delivery, first class postal with proof of delivery or proof of receipt, in the sense that the post office have received it, and then it would be validly served 2 days later. That's what my agreement says. So that's what I would do in relation to making sure that your agreements are protecting you as the landlord stroke evidence. So let's have a quick look at the methods that you can undertake. And as I said, I've sort of covered them already, but I just wanted to put more detail to them. So the three methods that I would always advise is first class post with proof of posting. So that's basically putting your notice into an envelope, and you can take a photograph of you doing that if you wanted to do so. Then you take it to the post office and you give it to the counter clerk, and he or she will give you proof of posting. And that will prove that you gave to them an envelope to go to a particular postcode and house number or flat number. Now, the reason why that's important is because on the balance of probability, was that letter delivered to that property validly? Now, I fully appreciate there's some arguments about the efficiency of the post office, but on the balance of probability, or the Royal Mail, should I call them, but on the balance of probability, the law would say there's a very, very, very good chance that it got there when you said it got there. So that's what it's about. It's about giving you independent evidence that you gave to someone, an organisation who is recognised, a letter or an envelope which contained the notice that you were serving in relation to Section 21 and Section 8. Now, the reason why I would not send it recorded delivery is because recorded delivery may come back to the Royal Mail or the Post Office if it's not been collected or signed for by the tenant. So as my other point down there, as you can see, I would not send it recorded delivery, always by first class post with proof of posting, because the postman will put it through the letterbox or into their letterbox, irrespective of whether the tenant wants it or not. I've not had the situation where they've taped up the letterbox, and that obviously from your perspective may mean that you have to do hand delivery instead. But if they did that, then you also need to consult with the Royal Mail Post Office about what they can potentially do for you. So first class post with proof of posting, that's the first bomb-proof method. The second bomb-proof method is the one that I've just mentioned, which is hand delivery with photos or a video or a selfie. And in some cases, I would take a witness with you in that sense, to write down exactly what happened, what time it was delivered, was there any answer by the tenant, etc., etc., etc. And that evidence, again, can play a key part in relation to proving on the balance of probability, as I said, that you had validly served that notice. So they are the two bomb-proof methods that I would always do. I would not do them, either of them on their own. I would always do them together, as in I would do the post office delivery or the Royal Mail delivery, and in addition to that, I would do hand delivery with photos, video, selfie, and my witness statement. And in addition to that, by email. Now, I would never do email on its own, and I would never rely on email, because in the end, the tenant could say, I changed my email address. One thing that they will never change, in a sense, is the property that they are renting from you. So therefore, you would always serve it to the property. Now, if you knew where the tenant had gone to, you can always serve it to the other property that they've gone to in addition. So you serve one to the property that they're living at or they have a tenancy agreement for. But if you know they've gone to another property, you can serve that to the other property as well in addition. So that particular slide is a really important one in relation to the methods. First class post with proof of posting, hand delivery with photos, videos, or a selfie, and then in addition to that, email. And obviously, in terms of the hand delivery, you can get a witness statement from a third party who said they saw you do that. And they're all the things that would be on the balance of probability. Has that notice been validly served? Yes, it has, even if the tenant argues or alleges later on that they never received that notice. So long as you can prove it was validly served, on the balance of probability, the judge should allow. You can never say never with judges, but I would say from all my experiences in 26 years, I would be very, very surprised if the judge throws it out if you have the evidence to back up what you're saying. Now, I'm just going to stick up a notice which some judges, or a court form, should I say, that some judges expect you to fill out. It's called an N215. It's a certificate of service, and hopefully it's going to appear on your screen as we just said. Hopefully it's just appeared there. If you just put N215 into your Google, it will pop up. It's a certificate of service. Let me just enlarge it so hopefully you can see it. I'm not too sure how easy it is to see. So most of the questions are, or most of the filling out is relatively simple in the sense it's only asking for information that you will have to hand as the person delivering that notice. But again, it's a good one in relation to just sort of being compatible with what the courts want. So some judges will want to see one, some judges won't. So again, there is no harm in filling this particular form out. And as you can see, it's just got name of claimant, name of defendant, what day did you serve the notice, who did you serve it upon, how did you serve it, where did you serve it, and then basically signing it and dating it. So it's not overly complex. It may look complex as it uses legal jargon, but it's relatively straightforward. It's only asking for information that you would have as a landlord or agent. So they're the methods. And then my last slide is about service time, which is really important. So this is really about Section 8s and Section 21s, as I was saying to you before. It's really about making sure that you have given sufficient time for the notice to arrive at its destination. So legally, you should always follow what the contract says. That's the first thing. And my contract says it's potentially valid 2 or 3 days after the notice has been served. So I always allow 3 full days. That's always the best way of doing it. That gives you the best ability to protect yourself. Because if you don't serve, or if you don't add extra time to your notice, there's a very good likelihood it will be dismissed. Now, as you can see here, when I say allow 3 full days, that also includes Saturdays, Sundays, and bank holidays. So I'm giving you sufficient time just in case. If you serve on a Friday, then you can just add 3 days. That's fine. I've got no problem with that. But if you wanted to allow extra time for bank holiday, if it was Christmas, I have no issues with that either. But I think 3 full days is sufficient in relation to service time. The one that sometimes people get me about or ask me about quite a lot is the 4 p.m. Daryl, I've been told if I serve it by 4 p.m. on a certain day, it's deemed to be delivered that day. Now, that only applies to court paperwork, and a Section 8 and a Section 21 are not court paperwork. So therefore, from that perspective, never, ever serve notice assuming it's going to be deemed to be served on that day. You always allow up to, well, I would say a minimum of 3 days for the notice to arrive. Even if you were serving it by hand, there's no point going to court arguing about 2 days in relation to service time, because you might have spent a huge amount of money getting there. So for your own risk appetite, it would be absolutely advice from me that you always add 3 days to your notices in relation to service time. And you can see the example at the bottom here. So my section was served on the 1st of March. So I'm going to use my Section 21 as an example. It has to be a minimum of 2 months long. So that would be the whole of March, the whole of April. So potentially it would expire at the end of April. But because I'm allowing service time, I've added 3 days. So my notice would expire on or around the 3rd or 4th of May. And you can put the 4th of May just for absolute safety. So again, my Section 21 was served on the 1st of March. I have to serve 2 months notice as a minimum under Section 21. And I just add 3 or 4 days for delivery time. And that would mean that my notice expires on or around the 3rd or 4th of May. And that, from your perspective, is the best way of protecting yourself in relation to courts and saving yourself from any arguments from the defence team or potentially the judge. Some judges are really awkward on that. They always expect 2 days as a minimum. Some may expect 3. So if I just use Section 8, for example, so Section 8 notice under rent arrears is 14 days. So if I served it on the 1st of March, it's 14 days minimum, plus three days for delivery. So if I served it on the 1st of March under a Section 8 notice with my 14 days notice period, it would expire on or around the 17th or 18th of March. So that's another example in addition to the one you've got on your screen now in relation to the Section 21 notice. So from that perspective, that's the best way of protecting yourself and ensuring that you've given sufficient service time for the service of a Section 8 or Section 21. I think that's long enough for this particular video, but if you found it useful, please put some comments down below. Otherwise, if you've got any questions, then please don't hesitate to contact me. Thank you.